How you doing out there, Funk fans? This is Professor Phil. Um, as you can see, I have the U.S. Citizenship and Immigration Services up. Now, you wonder why I'm doing this. And you'll also see a very nice, transparent link here, right here. See this right here? I'm going to pull it down a little bit so you can see it. That's one of my politics and money logos. All right, just to express the content and nature of that form of transparency you may see in the foreground there. But we're going to talk about something relatively simple and break down the administrative side to citizenship, which is very important. And for the most part, evoking one's dual citizenship is abundantly the basis for financial gain on part of the Department of State, which is the entity which subscribes you to citizenship in the first place. Now, the first place to look for the administrative side to this is going to be, I can't do that, but I think I can do this. This is the administrative form that has to be. God, man, my thing is really slow here. Hold on, I'm gonna do it from there. We go. The filing fee, which is basically the application for waiving one's citizens' rights via the Constitution, making you a 14th Amendment citizen, contracting with the United States and its counterparts, the states. Now, in the case of actual employment, you can see the fee is $595. I've already written them. I'm waiting for them to correspond. That fee is actually waived at birth, in which I'm then going to get into the birth certificate, and which is going to specify that there's no actual value to it as a abstract contract to initializing the vital statistics means of keeping track of nationalistic people by their nationality and their ethical codes, which apply to each particular group, unilaterally and bilingually. Okay, and this means if you speak a foreign language or some of that nature, you're still under the same rules and obligations, but depending on the guidelines of what you're trying to contract under or for, thus the benefit of the state or the United States, that's going to be an abstract agreement between you and them, and depending on how it is set up, that is going to be the consistency of the language of the Americans' legal determination of domestic policy. Now here we are, attorney or representative. You may be represented at no expense to the U.S. government. By an attorney or other duly authorized representative. This is how you get employed by the United States government. Now, even though this sounds ridiculous because you're not actually entering, but here it is right here. As you can see, notice the entry or appearance as attorney or representative. Now, their form is here. Ah, boy, this thing is really just. I'm just gonna go to the page because it's really slow apparently. This is the form that we're looking at here. Okay, this is DHS, Department of Homeland Security, and this is the accreditation for them to act on your behalf. Right? This is simple stuff. Right? This is relatively simple. Notice to appear, but check this out. You're not gonna believe this. This same form, as you can see, a petitioner, that's going to be, even though they're going to act as a respondent, they're actually petitioning as an applicant. So they're going to check these two boxes. Those will be the proper boxes. Okay? And when they get done doing that, say you got to go to court. Now you see here, citizenship requirements for employment of the judiciary. Now it says the current appropriations. Appropriations mean money. Law prohibits the use of appropriating funds to pay the compensation of any employee of the U.S. federal government where the duty location is the continental U.S. unless such person is a citizen, is a person who owns allegiance to the United States, U.S. national, blah, 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 is a person admitted as a refugee or granted asylum who has filed a declaration of intention to become a lawful permanent resident and then citizen when eligible, or is a lawful permanent resident who is seeking citizenship outlined in that particular statute. Here you're going to see. Okay. Now I'm going to pull that up, and where we looked at the application and the fee, we will go to Google, and then we are going to, and I don't know why exactly I'm so slow, but apparently I just couldn't tell you. But this is going to be a relatively simple breakdown as into what this means. Actually, it takes me back to this, the actual courts in which would administrate that particular statute, and the one we were looking at actually was 1324. Sorry, we're going to go down here, 1234A. Okay, and then we're going to take a look at unlawful employment of aliens. Okay, statute making employment of unauthorized aliens unlawful in general. It is unlawful for a person or other entity to hire or to recruit or refer for a fee for employment of the United States an alien, knowing the alien is an unauthorized alien with respect to such employment, to hire for employment in the United States an individual without complying with the requirements, which means that they can waive that on the note that you are associated with them. Of this section, if the person or the entity is an agricultural association, that means if you're in California, you can get a waiver to allow someone to work on your plantation for practically little to nothing, and none of the laws apply to that person. So $2.50 going back to, say, Mexico, or back to, say, some foreign country that's nearest to us, maybe even Canada in some cases, they can get away with this type of stuff. To hire or to recruit, to refer for a fee for employment in the United States an individual with complying in the complying with the requirements of Section B of this section. Continuing employment, it is unlawful for the person or other entity, after hiring an alien for employment in accordance with this paragraph, to continue to employ the alien in the United States, knowing the alien is or has become an unauthorized alien with respect to such employment. Now, I would say to someone like the Moors or these sovereigns that want to act foreign in their capacity, the problem with this is that when you're employed, you see, when they actually take simple fee, which is how much was it? Let's go back to it. It was 500, I believe, $85, if I'm correct. Let's see here. And it is right here. Yes, sorry. No, I'm sorry. $595. This is how much your application to contract with the United States had cost in order to get you as part of the Revenue Division of the United States, in which the United States, at no expense to themselves, allowed the United States to give an authorized representative to duly act upon you. Now, the great part about this is, as part of them complying with this particular statute, and citizenship goes a dual contractual effort on both ends of the plane. And as you can see here, we're going to go down to how the United States employs themselves. To comply with this requirement, number 4 above, an individual must be lawful permanent resident, have a green card, and apply for citizenship with, you know what, I'm going to skip right over that, and I'm going to get to the actual employment, indicating exactly what needs to be done before anyone can even enter into office. The appropriation law requires apply to anyone appointed into a paid position with the judiciary in continental USA, or that would be USA Incorporated. The appropriations law requires do not apply to employees with the dually stations of Alaska, Hawaii, Virgin Islands, Puerto Rico, Guam, and Northern Mariana Islands, nor do the requirements apply to unpaid volunteers. It says judicial officers, and of course, if you're a participant in the federal government, you are a volunteer. You are volunteering your time, and you're ultimately not getting praise. Neither are you getting some form of compensation, directly or indirectly. So that should tell you a little bit about your contract with the United States. Judiciary officers must obtain concurrence from the administrative offices of the United States Courts, Office of the General Counsel, to appoint an individual who is not a U.S. citizen. It says here, in the addition to the above appropriation law, the United States Department of Homeland Security, U.S. Citizenship and Immigration Services mandates all federal government agencies in the continental U.S. comply with the Immigration Reform and Control Act, which states that the federal agencies must hire only U.S. citizens and aliens who are authorized to work in the United States. That means if you're a solvent or you're more or you're a dietary or you want to just flip out and say I'm a diplomat because I can act in dual countries simply because I claim I can, then this right here would simply apply to you under the jurisdictional benefactor, that if you are acting in a foreign capacity, you would have to you simply have to still waive the fee for the application to act in commerce via the contract in which they established for you at birth. Okay, this is the abstract of contracting your benefits. Now again, we're eventually going to get to the appropriations themselves and the immigration. I'm going to go into immigrations in just a moment. This is a hot button second here. But we're going to go down here. And the last sentence: all individuals appointed by the Judiciary Office must complete the employment eligibility verification form I-9, certifying their eligibility to work in the U.S. Now here's the crazy part. U.S. justices, they have to file it, yes they do, in order to ensure that they are being employed and they are legally applicable to act as a representative. See this right here? Employer authorized representative to review verification, blah, blah, blah. The basis of all of this. Now remember, you can always stop this and push rewind. You know, this is something that if you're watching it, you're able to watch it at any given time. And the application that you're excuse me, that you've if you're not catching up here, if it's taking a little bit for you to catch up to this information, then stop it, rewind, and play it again so that it kind of soaks in. I've been told by individuals that sometimes some people can't keep up, and sometimes you just simply should not be watching this and then, you know, kind of have the nerve to get upset because you can't keep up. Again, you can watch this repeatedly, okay, if you're watching this at this time. It says, what is the filing fee? There is no fee for completing the form I-9. This form is not filled with the U.S. CIS or any government agency. Form I-9 must be retained by the employee and made available for inspection by the U.S. government officials as specified in the Privacy Statement Act, in which they have enacted. Now here's the crazy part. While you're paying for that application fee to act as the United States citizen, which is your contract, which you either waive by stipulating there are no appropriation or benefits, thus there's been no contract by the United States Citizens and Immigration Services, who applied you as an attorney, probably the Attorney General, co-signed the authorization at the state level and then given to the federal level to act as your dual authorized representative, which of course is a dual contractor. That means that you're under the United States Constitution as well as the as the state constitution in which you're in. Thus, if you pull up any oath of office that anybody has ascertained in that state, they are dual contractors and they pledge to uphold the United States and the state government's contracts. Now here, I'm going to get you over here. Here is your, again, the attorney, which is an accredited representative. Now remember this, forget the notice of entry, okay, and look at it as an appearance by an accredited representative. That's what you need to look at. If you're going to be a dual citizen or you're going to be a dual contractor in which you're privileged to stay here, but you have a contract which is outstanding with another nation, then you have to go through Homeland Security and the Department of State in order to be reconciled into the today's laws. Unfortunately, the Constitution, in which was that of the Praetorians of this nation's beginnings, unfortunately had been waived upon the authorization of this new government that is installed. Whether or not its dictatorship is applicable to the feather and cushy assumption that we're all free upon the exalment of the later day uh, government infrastructure that was put into place to supposedly free all men of this dictatorship possibility, which had been in place well before it even was conceded to be believed that all men were free in the first place, which of course meant that somebody had to play a citizen, meaning a slave, and someone had to act as a dictator over the land in some way, shape, form, or fashion. Whether it was a it was a state or a comptroller beneficiary who would act as the slave holdings for the South, or if it was the industry which pursued, pushed, and authorized without absolutely no type of oversight by a government entity, the great praise of building huge industry on the backs of those in which they broke in order to get where they are today. Okay, so whether or not you want to look at it the way you want to look at it, whether you're Irish or black or Japanese or whatever you like to call yourself, you ultimately were a part of the slave mandate to build something that your forefathers suffered under. Not all, unfortunately, were a part of the establishment of what the government we know of today is, but this government is just embarked on being noticed as being the absolute government entity as we know it today. All right, so we'll go back to the form that we were looking at, and this is interesting. It gets very interesting because if you notice, if you want to be employed, and it says it by its own site's admission. Its site is, as you'll see here, uscourts.gov careers forward slash careers / career citizenship requirements .aspx. Okay, so that's uscourts.gov / careers / career citizenship requirements .aspx. So you're going to go down to here, you're going to see employment eligibility verification form. And then once you get there, you're going to be looking at what I'm looking at, which is relatively simple. And thus, when the employer is asked to retain this copy, say you're in front of a court, you're in front of a judge, the next question is that these people have ascertained a particular form of identification by Homeland Security as being a contractor privileged to act on behalf of someone that is a citizen, which they are. Okay, now they can specify that they're a non-citizen, but they have legal intent for national security purposes, which of course is where the instructions would specify what you have to break down in which you would define a non-citizen in legal terms. All right. And then, of course, they go through the information, such as if you'd been to another nation, maybe whether or not you had a number or a registration number, verifying where you might have gone as far as your not your nationality, but where you may have transpired business in the infrastructure or in the sense of national financial security for domestic purposes. That, of course, keeps their eyeball on who could be a domestic problem and who can be a international problem within the domestication of laws, foreign and aboard. So we got all this good stuff. It's real nice. You know, they tell you what kind of documentations that you may have had as an employer, as employee of a foreign corporation for some purpose or another. Of course, they're looking at their domestic policies to ensure that they're going to benefit the most from you. Of course, they ask you for a certification as an employee. At any given time, this particular item is for the purpose of ensuring that anything they say, you can see here that they do their forms of certification for the duration of their employment, that as an employee of the United States, which of course means that they are a client. If you're in the United States courts and you see that an employee has a contract with the employer and the employer is trying to prosecute you, then apparently it's a dual contract. Thus, they're upholding two principles. One, the revocation of appropriations, which are monies available to themselves as part of the exchange of their employment. And then they have to have certain documents that would be listed to identify themselves as part of the liaison of authorizing them to act on your behalf, which is they have to, any citizen that's a contractor has to act for another citizen. Thus, the judge is no different than you are when it comes down to who you are in the artificial sense and how legally you are going to be applicable under private law. Now, remember this right here, very simple. Employer or authorized representative review and verification. This tells you what they are as they know of each other on receipt. Acceptable receipts. Okay, that verifies the nature of where their appropriations are going to come from, who pays them, and who authorizes them to act, and that is the Department of State, to give authorization to the United States' esclaves that act on behalf of lands that are incorporated by the hands of their business infrastructures, buy and sell grievances between those states and the entity in which the United States government has applicably been recognized as being.
It's 1 o'clock.
And since it's 1 o'clock, and so out of all this operational financial obligations between the entity and the federal government and the states, this should give you a relatively good idea of what we're dealing with, as far as that of if you want to be a dual citizen, you want to be a dual contractor, you believe the law should not apply to you, well, then you're going to have to take a real good look at how the U.S. immigrations and citizen services, as far as their bandwidth and their extension of what applies to you and what does not apply to you on the business infrastructure and their financial obligation of a $595 credit that you are a U.S. citizen. Okay, this is the formal checkpoint for financial grievances in which the United States government authorizes its representatives at no expense to you, but financially an obligation to themselves as something that they have granted as a waiver to grant you asylum as a domestic decal, which of course they will recognize as long as you're not trying, or you haven't become a part of a dual matrix which supersedes them. That could be very threatening, of course. So we're going to get into actually I'm going to leave this Immigration and Nationality Act so that I can bring forth the grievance of the birth certificate in its conceptions that are it's been plagiarized in such a way that it's supposed to have some alternate financial value, which it has none. There's no statutes that apply to them. I'm even going to call the vital statistic offices of several states and figure out whether or not they are establishing that under contract they validate that there is some type of financial value to it. The only financial value you will find out of it as an obligation to the United States or its entities is only one specific neutral purpose, and that is to get the signature of two parties who agree that you are partly responsible for these laws being enacted because of the burden of the state or the United States taking care of you, and you being a welfare recipient, a contractor pledged to pay back the national deficit back, which we all know is almost impossible to do, for financial and underwriting purposes. I'm really going to dig into that birth certificate ideology because it just doesn't seem to go away. I always seem to hear about it, and yeah, I'm going to make sure that the only receipt on any of my ventures as far as this incorporating these videos is to specify only one topic and one topic only, and which is how much does it cost for a birth certificate. And if a birth certificate only costs, say, $20, $20 is a receipt for a deposit in which grants you the benefit to act as a as a national under the Nationality Act, and then the grievance in which you can take that $20, reduce it to zero on the principle that you're not using the Nationality Act, and thus increasing the probability of having to go before the Department of State, and then giving the Department of State the grievance in which they've taken a $595 debit, which is credited to you as the Immigration and Nationality Act is used federally to mandate all states to incorporate the Immigration Acts, in which domesticates you as a contractor, privileged to have a contractual obligation to pay the national debt back upon this birth certificate, which you think has this ridiculous and astounding amount of money that is just floating around in escrow. I'm going to seriously take a huge bite out of that. But until then, this is Politics and Money. It's Professor Phil. You already know I'm in the building, and it hurts. You already know if you have any questions, want to make dialogue, or would like to correspond in some way, shape, form, or fashion, my number is 424-245-9408. The email address you can correspond to is Philip Gillon, PhilipGillon, the number one, not the letters, number one, at iCloud.com. I'm out.